Of course, this morning we asked you, let me just do a little fresh here to get some more votes. Do you agree with the state's decision to appeal the judge's decision to uphold the multi-million-dollar ruling in the Joala Rambaran wrongful dismissal lawsuit? All right. So far, the no's have it online, and the no's have it on my pen and paper from our callers and messages. All right. So far, we had 20 folks saying no and 6 folks saying yes. All right. All right. So that's it. Yes. So our guest this morning, Senator Sean Sobers. Welcome to the Power Breakfast.
Former Senator Sean Sobers.
Former Senator. I did.
Sobers, you ain't pay light bill, how you? I'm so dark,
No, I don't know. We're really lighting in the room.
Things bad out.
Paul.
I want to also congratulate. I don't know if it's appropriate at this juncture, but should I also refer to you as Dr. Paul Richards now?
You can.
Yeah.
Paul is fine. Thank you so much.
Dr. Paul Richards, is there something I don't know? Something happened when I was off for a couple of weeks? What happened there, Paul?
Steve is generally 2 weeks behind time, so we'll excuse him.
2 weeks. Dr. Paul Richards, is that correct?
Yes. I saw the article online. Dr. Richards would have completed his doctorate at a university, I believe, in the US.
Andrews, yes.
Yes. So congratulations.
Well done, Paul Richards.
Yeah.
Steve a little later.
Yeah. I'm 2 weeks behind time.
Like
right now in the middle of October.
You know what it's called?
Paul, I don't know if
most of our
listeners knew that.
Sorry?
I don't know most of our listeners knew that.
Yes, they did, Steve. You are the one behind time.
Listen, leave me alone. I'll put
long COVID, I understand.
Mm-hmm. Well,
anyway, good morning, Sean Sobers. Thank you for joining us this morning.
Thank you so much.
All right, lots happening in the country. Let me start with our question this morning, and a kind of rhetorical question for you. Our question this morning was, do you agree with the stated intention of the state to appeal the Joala Rambaran $7.5 million ruling for wrongful dismissal? And what say you? He asked rhetorically.
Well, it's interesting that you would say it's rhetorical. Being an attorney at law, I do understand that any litigant before the court has an opportunity to appeal a decision of the High Court, to appeal a decision of the Magistrates Court, and even to appeal a decision of the Appellate Court. So it is well within the rights of any litigant, be it the government or anybody else, to adopt that position. My particular position is that, unfortunately, what I've come to understand or come to realize with this particular administration is that they have turned some state agencies into basically litigation mills. So it is easier for them in their own eyes.
What does that mean? What does that mean? What do you mean by that?
So let's say, for example, EMBD, the Estate Management Board entity that was set up to help develop lands throughout the country. A lot of the claims that have come to the EMBD, some of the claims which should in fact be settled, if the settlement should be done over time, periodically, or whatever the case may be, which would save the taxpayers money in the long run, have contractors working, generate employment. Instead of doing that, what this administration has done is essentially transform the MBD into an entity which basically says no to all claims. We are not paying anybody. We prefer to go to court, and we will run up the proverbial legal ladder.
But isn't that as the phrase goes, if there are concerns about the way those contracts were handed out and the deliverables attached to those contracts, shouldn't the state seek the public interest in making sure that the process was proper, as opposed to just paying out claims that are brought before the state where there are major concerns identified?
And you're right. So that in some of those instances, I do agree with you. If there is expert reports that indicate that certain works would not have been done, there are engineer reports from the way in which those contract law positions operate through FIDIC. You have the engineer who's the consultant, who's really supposed to be the one protecting the state, who's the client, against bad works or insufficient works being done by the contractor. And if it is you have an engineer's report that indicates that works weren't done satisfactorily or no works were done at all, then obviously you don't pay and you litigate the matter. But there have been reports coming from engineers. I have been involved in some matters against the MBD where you have the engineers indicating, yes, we've delivered what you call interim payment certificates to these people over a period of time and they've not been paid. So you need to pay them. And there's no reason sometimes when these matters are advanced through the courts, sometimes through arbitration first, which is like court in and of itself, just without a judge. There's an arbitrator, but you follow basically the rules of court. And then if it is you're not satisfied there, after spending millions of dollars on private attorneys, then you go to the High Court and you go through the entire same process again. And some of these approaches, and that's why I answer that question in a particular way. The approach that we've seen with this particular administration is that they intend to appeal sometimes on interim points during a matter, and that stops the substantial proceedings for some time until those interim points are settled. And then you go back to the substantial matter, which costs the taxpayers a lot of time and a lot of money as well too. And so even in my own personal practice, I always advise clients at this juncture where money is scarce, try and do what is commercially viable, the most commercially viable position to adopt. That is what you should in fact be doing. And I don't see the state in a lot of these matters adopting that particular position.
Well, the overall issue that has come into the public conversation recently is really part of what you're saying is exorbitant legal costs the state is incurring. Yeah. But that is not exclusive to this administration. That has been the concern through several different administrations and through the Office of the Attorney General, Ministry of Legal Affairs. And now there's a conversation about legal cost, what is applicable, the briefs that are handed out to X, Y, and Z, and is the public getting value for money, or is it, as you call it, as you termed it, litigation mill, not only in this administration, but in previous administrations past? So how is the public to reconcile what is political and what is actually beneficial in the public interest?
Sometimes I think God leads us in a particular way. And so whilst I was waiting to log on, I was on my telephone and I saw an article from Senior Counsel Martin Daly, who was speaking about the very same thing that you are addressing currently. Mm-hmm. And he attempted to demonstrate chronologically what used to be the position in times gone by with respect to litigation.
I saw that article and going through the state prosecutor's office and stuff like that.
Correct, mm-hmm. Yes. And it is in my humble opinion that there should be a return to that. That we have so many lawyers coming out from law school. There's going to be a call, I think, next week where we have maybe 100+ lawyers coming out. And there are so many gaps within the state that these people could be absorbed. And instead of spending millions of dollars on attorneys privately, they should be put to work for the state where they are paid a salary and they deal with the matters accordingly. And Martin Daly made the point in that.
And gain capacity and learn also in the process.
Correct. And there have been excellent attorneys who've come from the Solicitor General's department, who've gone on to be judges, senior counsels, excellent private attorneys in their own right. And I want to say this as I keep it. I cast no aspersions on any lawyers, both under the previous administration or this particular administration, for the work that some of them are doing. Some of them are eminent senior counsel, and I owe them that level of respect and deference. But at the same time, I agree with the position articulated by Mr. Daly SC, in that we need to look at how we can bolster and buttress our state Solicitor General's department with all of these young budding lawyers coming out. And essentially they'll be thrown in the deep end, but that's the best way sometimes that you're able to learn and grow.
Yep, you learn to swim by swimming. Richard Ragoobarsingh, good morning. Thanks for joining us.
Good morning, Paul. Good morning, Sean.
Good morning, Mr. Ragoobarsingh. How are you?
After running for 3 minutes, Richard takes over for now. Our substantive topic is, of course, the issue of the former AG and the issues related to the Vincent Nelson case. And just for clarity, and those who may not be following it in local media, what is the UNC's position?
So our position is quite clear. We, from what we have received in terms of information coming to us from the printed press and otherwise, you have a situation where you have a state witness, which is not something abnormal or out of the ordinary, who had certain information, wherein he indicated basically that there were certain wrongdoings occurring in the Attorney General's office, and he was minded to provide that information to the relevant authorities. And our position as the relevant authority under the Constitution in this particular case for criminal matters is in fact the DPP. And so, Dr. Richards, you would bear me out on this. You were in the Senate when we passed that plea mitigation and plea discussion bill, which is in fact law. And there's no feature of that bill where the Attorney General is supposed to be part and parcel of any negotiations or plea bargaining discussions at all. And so for the Attorney General to have entered into the arena in whatever capacity that we are now becoming aware that he has with respect to this indemnity agreement that he forged with Mr. Nelson, it murkies and muddies the position. And so any jury that becomes aware of that particular position, I mean, persons watch television, they see these things all the time, where persons turn state witnesses against their alleged co-conspirators in an incident. The first question that the defense counsel is going to ask, were you induced to come here to give this evidence that you're coming to give against your former co-accused or your former individuals who are charged before the court? And once that person admits yes, and then that person goes into what that inducement was, the entire matter is solid. There's no way back from that. And that is going to lead to an acquittal. And the question that has to be asked is, why did the former Attorney General engage in this type of behavior, engage in this type of conduct, overreach as he did, which is what our position is, when the law, the Constitution is quite clear that it was totally outside of his remit.
Yeah, you know what's a little confusing about that entire issue?
Yeah.
What exactly, if there was some sort of plea bargaining or plea arrangement with the DPP, what was it? Because the only plea bargaining that we are aware of, at least that's being publicized, is the indemnity agreement with the former AG and what was signed there. But was there one with the DPP in exchange for the information with regard to whatever information he was given with regard to the former a previous AG and a former member of the Senate? And so you weren't sure, was there? Because you're right, in that act, the remit really is that for the DPP to do. But what agreement did the DPP have? Or was there any?
Well, I am not seized and
And his
possessed.
defense counsel.
Yes, I am not seized and possessed of any facts as it pertains to an arrangement with the DPP. What I can say is from the sentencing aspect of things, Mr. Nelson will have been fined a tidy sum of $2 million. Now, essentially, for what he was alleging that took place, Mr. Nelson actually could have faced a harsh, extremely harsh custodial sentence. So I don't know if it is in terms of, and I'm saying because I am not seized and possessed of those facts, I'm suggesting that there's a possibility then that there may have been an arrangement. Well, listen, if you give this information, we will not recommend a custodial sentence. Our recommendation would be, in fact, that you are fined. We would also possibly give a recommendation as to what the fine could likely be and let the judge determine that position. That is as far as I think the DPP may have gone if he did in fact go in that direction. I'm not seized and possessed of those facts. But this position with respect to paying legal fees and it's the indemnity agreement, unfortunately, is absolutely ridiculous. And as I said before, if that was to ever find its way well in front of a jury, that matter would have definitely been dismissed. There would have been an acquittal.
Yeah.
How much real is it that the former AG has indicated in a press conference after a lot of the information came to the public domain that he was advised by senior counsels, Gilbert Peterson and is it Russell Martino?
No, Douglas Mendes.
Douglas Mendes, also senior counsel, right? If I'm not mistaken. And he had leaned on that advice as the Attorney General with regard to how to proceed or the options to proceed in this matter. Let me put it that way.
Mm-hmm. I slightly disagree with you a tad bit, Paul, because based upon my recollection, what he actually indicated is, listen, I forwarded the indemnity agreement for senior counsel to settle. And I made the point at my last press conference, when lawyers use that term, generally what happens is you have a lawyer, possibly a junior lawyer, possibly what we refer to as a junior senior lawyer, someone maybe 18, 19, 20 years in practice, just without the silk title attached to his or her name. They may prepare a document, and just out of an abundance of caution, they may forward the document to a more senior person who is more okura with that area of law to settle the document and then forward it back. Now, settling a document doesn't mean that I rubber stamp it or I punctuate it and say, yes, it's good to go. I may have some concerns, and I would attach those concerns to the document. And then it's for you now to essentially take my advice or don't take my advice.
Well, I ask the questions in that context, because at the end of the day, to me, and please correct me because you're only the attorneys, the Attorney General can and should seek advice from persons who may be more knowledgeable in any particular sphere of law.
Correct, yes.
But the final decision rests with the Office of the Attorney General. And that is where the responsibility for the decision should lie, essentially.
Definitely, and I agree. And that's why it started, the genesis of it started totally wrong. This person, for whatever reason, through his attorney, whether or not clearly based upon what we've seen coming out from the press, there existed some type of relationship between the man's counsel at the point in time, Mr. Ragoobarsingh, and the Attorney General. That's fine. He reached out. He says, listen, this man is willing to say X, Y, and Z. Our position is, as a party, is that at that juncture, essentially what should have taken place, and it was critical that it took place, he is to say, listen, I appreciate the fact that this man is minded to come forward. The correct approach is, let me contact the DPP's office and set up a meeting for you all to go there and arrange to have a discussion there. That is outside of my remit, and I will not get involved in it. And whatever machinations that Mr. Nelson may have had, or to encourage him or entice him to come forward, the DPP at that juncture would have been able to say, he would have been poised and in a proper position to say, listen, I'm not minded to give you what you're asking for. That's nonsense. It's either
I'm glad you mentioned that, because at the end of the day, some are suggesting also that whatever the former Attorney General may or may not have arranged or negotiated is one thing. The DPP's office is an independent office and can say yay or nay to whatever recommendations come from the former Attorney General, because there was a document in the public domain.
Yes.
Attributed to the former AG, which in paraphrase said, I am aware of the boundaries between offices and the independence of your office. However, it is my recommendation, I think was the word used, that consideration be given to this scenario.
Yes.
At that point, it is up to the DPP to say yea or nay. The other suggestion added to that is, was the DPP then bounded? I suggest not, because his office is independent.
Yeah.
Any arrangement made outside of that office, or outside of the approval of and consent of the DPP's office to make that arrangement, given the independence of the DPP's office. Am I going beyond the law here?
No, you are on point. What I would add to that is this: I am aware, based upon exactly the same letter that you're referring to, it appears to me that when that letter reached the desk of the DPP, he's basically indicating to the former Attorney General, I don't know anything about that, That document and its contents and whatever else that is connected to it, you cooked that up on your own. And you didn't do so with my input, which is what you should have done. And at this late stage where you're now introducing this to me, I am not minded to get my office involved in that and let the chips fall where they may. That's what I took from it. There was another point that I was
But at some stage, didn't the office of the DPP have to acquiesce to an arrangement, given the fact that the DPP eventually dropped the charges, so charges were laid?
No, I don't think the DPP had to acquiesce at all.
Okay, I'm asking a question. I'm asking a question.
I think the issue became how that entire arrangement affected the proceedings with regard to the DPP was the seeming unwillingness, as articulated by the defendant, that I am not willing to give information while these cases that I have against the state for an agreement that I think the state is in breach of, meaning that side of the state, the Attorney General side. That's how it started to affect the criminal proceedings, at which point the DPP said, well, look, this case is untenable. It's not fair to the defendants in this matter, and therefore I am discontinuing the case. So it started to affected in a kind of proxy way through what Victor Nelson was articulating to the DPP. I'm not willing to give this evidence until this agreement is held up in my favor, which can't be a tenable position for DPP, quite frankly, in terms of a criminal proceeding.
No, I asked the question, Mr. Ragoobarsingh, to another senior criminal attorney about this. Because it appeared to me that when the DPP made that submission, I got the feeling that, well, obviously he was aware of this position based upon the correspondences sometime in 2020. The decision to drop the matter came in 2022 of this year. So that's 2 years onwards. And I asked that senior lawyer, why didn't the DPP then possibly indicate to the court what the position was since he became seized and possessed of the facts? What the senior lawyer indicated, well, listen, at the end of the day, that issue with respect to whatever indemnity agreement that may have been struck without the DPP's knowledge and input really goes to the credibility of the witness. And that is not an issue really and truly. It's a concern for the DPP, but it's an issue then would be dealt with by the jurors and by the judge. And so up until that point, even though he may have been aware in 2020 about this indemnity agreement, his hands were essentially tied. Listen, if the man is saying he's going to testify at some juncture...
Why would his hands be tied given the independence of his office? He can make a decision to not go forward.
No, but then the thing is, it doesn't affect it. The issue with respect to credibility, from what I was told, and in my opinion, practicing criminal law is not an issue that he has to treat with.
Okay, that's the court and the jury.
Correct. And if the jurors believe the person to be credible or incredible, that's their decision. But where you reached a stage now where the man is saying, I'm not minded to testify because of this indemnity breach or alleged breach, then that is a serious...
So are you saying, and I'm asking a question here, that the mere fact that a criminal act is alleged to have taken place, right? And the DPP is seized and possessed, I like that phrase, of information that may be able to help this case on behalf of the state, that the DPP can move forward and then let the court decide if he finds that the evidence or the potential for evidence meets a particular bar to present the court, the case to the courts and charge. Is that what the scenario is here?
In my opinion, yes, with respect to credibility.
Okay.
And that's why, because I asked the question, if he became seized and possessed of the facts in 2020, why not drop the charges then? And what I was told, and I agree, having practiced in that arena for a bit, is that at the end of the day, it would go to the credibility of Mr. Nelson's, his statement, him being there based upon him possibly being induced by this indemnity agreement to pay legal fees and other fees and whatever other fees and whatnot. And so it would have been disclosed. I think the Honorable Director of Public Prosecution would have disclosed the indemnity agreement at some point in time. And if Mr. Nelson decided and the agreement was being honored, he would go forward with the testimony. He would have to indicate the full parameters, length and breadth of that indemnity agreement. And then the issue of his credibility would have been left to the jurors to decide. And in my humble opinion and considered view, they would not believe him. I mean, when you think about it in a at least...
But indemnity and persons turning state witness is not a new phenomenon in jurisprudence.
No,
it's whether or not you think they believe him or not may be immaterial. It is that it is up to the prosecution to champion their position and the defense to defend the position. It comes down to that in the courtroom.
No, but how would you? I know that you are not an attorney, but you've been a legislator for quite some time. How are you as an attorney at law in a prosecution now going to defend essentially that a man has been paid to come here and give evidence?
Well, that has been my position over the last couple of weeks, but I am not, and I have been challenged by that. Yes. Because of the scenario that people who have allegedly committed crimes have fostered deals for their own benefit to give evidence against the crimes they are admitting to be involved in.
And in
but those agreements would have had to be between the DPP and the defense counsel.
Correct. And in most instances, is not to say that they would have been given a pass. In this case, Nelson was convicted and he was fined, right? The fact that he escaped a custodial sentence, in my opinion, is a good deal. But to say,
but what was that deal? But that's my point, Sean. What was that deal?
Well, as I said before,
because that deal is not the indemnity agreement. Because the indemnity agreement is not subject to the defense counsel of Vincent Nelson and the DPP coming to an arrangement or some plea bargain arrangement. So obviously there was one because there was a non-custodial sentence.
Yes.
But nobody is really training their eyes on, well, what was that agreement about? Because everybody's looking at the elephant in the room, which is the indemnity agreement.
And I think it's tethered to what Dr. Richards is saying. In most instances, if you have co-accused, and even you, Mr. Ragoobarsingh, being an attorney at law yourself for quite some time, you would also understand that in most instances, there are situations where persons, they turn state witness, the best thing that they may be offered is a lighter custodial sentence, or in this case, a heavy fine and a non-custodial sentence. But in terms of being paid, and being paid a tidy sum, some $11 million before for fees that was owed and all sorts of bacchanal that came out, that is in the media and what's not printed press. That is untenable. And
those are the scenarios that are coming out now to me that give you a visceral reaction that what the hell is going on here?
Yeah.
Because this person has confessed and been charged, been charged and convicted of a very serious crime.
Yes.
And to me, that is part of what I find a little irksome in this, and I'm using that term very lightly. The UNC, and please correct me if I'm wrong, is also calling on the present Attorney General to clarify this situation. I think he may have stated that some of it is before the court and it was sub judice. I don't know what the scenario is with that, because so much of it is already public domain, but that doesn't mean that some of it is still before the courts.
Right, but then MP Ramberley did an excellent job yesterday at our press conference clarifying legally what the position of sub judice is. And it is also connected to the Nankisun Bujram case, which the former Attorney General raised. Sub judice and undue public influence with respect to information coming out while some matter is before a criminal court can, in fact, in some instances, sway the minds of the jurors. And remember, judges are not machines. It could, in fact, have an alternative opinion or a negative opinion on the way in which a judge may deal with a matter. But this is not a matter that is before any criminal court anymore. And so to say that it is sub judice because there may be there's no appeal. The person who can appeal that decision, the only person who could appeal the decision really right now is the DPP, and he's not going to, because he's the one who made the decision to discontinue. And so, in our opinion, the Attorney General is using this term of sub judice, which is something that is connected to the Parliament now in terms of our standing orders, and which is a rule that is connected to criminal proceedings. He's carte blanchely saying, hey, I'm not going to speak about this because it's before the court. What is before the court is a civil matter that Nelson has brought. And no one is speaking about the merits of the case. What we are asking the Attorney General to say is let us know what the position is with this indemnity situation and how this thing was procured and the genesis of it. And that is why we are saying, additionally, if persons intend to remain tight-lipped on this thing, it is essential and critical for the TTPS to get involved and for some investigation to take place. As far as I am aware, as also, when the DPP became aware of this indemnity arrangement, in an attempt, what I in my considered opinion and humble opinion, in an attempt to get a better understanding of the situation, he sent the police to ask some questions to the former Attorney General. And that's why one of the questions that the police asked the AG, whether it be by email or in person or however it was, who else knew about this indemnity agreement? Who else did you discuss this with? And in one of the questions he answered, well, he discussed it to the Honorable Prime Minister, the current Attorney General, the Minister of National Security, Stuart Young, and others. And so I'm saying we cannot remain, the government cannot remain silent on this issue. It is one of national and public importance. And we need some answers from those persons involved, the people in authority. And if they are not minded to do so, the TTPS needs to get involved and procure those answers for the country.
The TTPS getting, the TTPS is getting involved because you think a law may have been broken?
I believe that a law may have been broken.
What law is that?
Well, I mean, we are of the opinion that there have been possibly several laws. We are thinking misbehavior in public office, perverting the course of justice. These are possible crimes that may have been committed if persons didn't carefully do what they were supposed to do. I mean, clearly, in overreaching in terms of what your constitutional remit allows you to do, by engaging an initial defendant and then a witness in a criminal proceedings when you should not have, and the DPP was the one to do so, there's something wrong with that. Whether or not it is in fact criminal and it meets the elements of the offenses that I've just called, that is a position for the police to investigate. And if they find that it meets a standard, then the DPP will advise them whether or not charges should be laid. But at the very least, an investigation should be conducted. If persons are innocent and found not to have committed a criminal offense, then let the chips fall where they may. And if it is in fact otherwise, the independent office of the DPP and the police, of which we have full confidence in, they will indicate otherwise as well too.
It's a lot.
Are you going to take some calls?
Yeah. Yeah.
Yes, I am.
All right. Our guest is Sean Sobers, former United National Congress senator. And we're talking about several of the legal issues in the public domain presently. And the numbers are, Steve, I never remember them.
222-8255. Toll free, North Americans, 866-525-1099. That's our numbers directly in the studio. We're taking some of your calls.
Sean, going back to that article that Martin Daly wrote, and there are others who have written about it. I see Noble Philip has also written an article that appeared on my timeline this morning about and this is not pertaining to this administration or the last one, generally, the issue of the Attorney General's office and how it operates in terms of review. Do you think that should be reviewed?
Absolutely. I mean, growing up as a young man within this country, I never really knew that lawyers would make these tidy sums of monies from the state. I thought it would have been based upon your reputation, the good works that you would do in the court privately, some lawyers practicing up the islands and at the Privy Council and whatnot. As I said before, I think we have a lot of attorneys, young attorneys coming out from Hewarding and elsewhere. And I think it is important that we absorb them into the state and that they start doing the practice on behalf of the state, learning the different...
But in addition to that, the way... And any Attorney General, to me, have the responsibility of making sure that the opinions they get are credible and proper and impartial, quite frankly, regarding matters that they need opinions on behalf of the state. But the way even those opinions are procured, it seems that there are issues where the system is open to possible abuse. Let me just leave it
because Paul, the issue of politics comes into the office because it's a political appointment. So the navigating of the road, so to speak, of operating in an independence and an objective manner always comes into question, no matter what whom the administration is, whether it's the UNC or the People's National Movement. That issue of the politics attached to that position always affects performance.
And it's a bit unfortunate because, to be fair, with respect to both administrations, there are some senior counsels who get work from both sides because their reputation well precedes them. Douglas Mendes has been briefed by the UNC, has been briefed by the PNM. Russell Martineau, senior counsel, same thing. Deborah Peake, senior counsel, same thing. So, I do agree with Mr. Ragoobarsingh that unfortunately sometimes the politics will play a hand in which attorneys are procured as opposed to others. And they have been called by some persons saying, well, listen, why lawyers don't tender the same way that you have contractors and others tendering. But legal advice is something I think a bit more tricky than just tendering to do earthworks and whatnot, and construction. And sometimes I think the attorneys general, whoever they may be, they've developed relationships over time with some lawyers who they think to be extremely good in a particular area of law. Those lawyers have impeccable success rates. No one would disagree with the fact that Douglas Mendes is an excellent attorney. Deborah Peake is an excellent attorney. Kelvin Ramkisoon, we have so many attorneys who are UNC affiliated as well too, who are excellent lawyers as well. And so that, I remember when I got called, I asked my senior at the point in time, what would be the blueprint that I should follow? And he said, listen, all you need to study is how quickly you could work hard to get at the top, because there are so many lawyers within the country who settle at the base, but there are so few of us that rise to the top, and it takes time. It takes a lot of hard work. It takes.
But even with that said, Sean, and I'm not dismissing anybody's credibility. What often happens is that there are some attorneys who become politically affiliated.
Yes.
Whether subliminally, or overtly, or covertly, and when this creeps into the scenario, questions obviously arise as to, and this doesn't negate their credibility, but to the closeness to the office holder and whether or not that is playing a part in them getting briefs or not.
Yes, yeah.
And to me, that is one of the big questions. This is not to do with their credibility or not, This has now to do with a political component seeping into the equation.
But then how do you treat with that? If
I don't know.
Well, this is the thing. If a particular lawyer is well versed in an area of law, and that is the area of law, for whatever reason, is engaging the state's attention mostly, especially in public law matters where there is an urgency to treat with the issue because it's a public law issue. You can't have it lingering on the books for quite some time. It has to be dealt with. It could change the landscape in which things are done, and there are very few lawyers within the country who are eminent public law attorneys. You would find often than not, their names are the ones that are called most of the time defending the state. If they do in fact have a relationship with the current Attorney General or former Attorney General, we live in a small island.
It's a small country.
That's just how it is sometimes.
Yeah. Especially practitioners in a particular field will know each other.
Yeah. Correct. Gentlemen, we do have a call, so let's grab it. Good morning, caller.
Hi, good morning, gentlemen.
Morning.
Yes, I'm hoping that Mr. Sobers will clarify something for me, because I'm listening to the conversation. The UNC's position is about the indemnity. That has been widely debated in the public, right? However, I assume that I haven't heard anything about their position in terms of officers who occupied office that were charged and allegations made against him. I'd like to hear his position on that in terms of the accusations made against the two class members of UNC, because there were bank transactions that were provided, information provided via the public too. Right? What is their party's position in terms of membership or any individuals that hold in public office, if there are serious allegations and they are charged, and especially the issue with Mr. Lee, if it is that you feel that the same position should be taken on Mr. Lee as was taken against Mr. Franklin Cad and Mr. Eric Williams when they stepped down. Thank you very much.
All right, thank you.
Right. Well, the party's position is quite clear on that. We essentially have said, listen, if you are in fact charged, you need to go before the court and clear your name. In the case of the former Senator Gerald Ramlin, he would have tendered his resignation and he went before the court. The matter has been dismissed. In the case of former Attorney General, well, he was charged subsequent to the UNC demitting office. As it pertains to MP Lee, the situation is a tad bit different in that he's an elected member of parliament. I guess the same applies when Mrs. Marlene MacDonald was charged as well. She's an elected member of parliament. At the end of the day, our constitution allows and it prescribes actually that persons are essentially innocent until they are proven guilty subsequent to going through the court's procedures. Having practice in the criminal arena, and I'm not saying that this is the position because I'm not going to speak on the merits of any of the cases. What we have in fact seen, what I have in fact seen, there are many persons who are in fact charged. And when you traverse the case, when the case is properly ventilated before the court, you recognize that there are several gaps between the evidence. There's several gaps between making up the elements of the offense. And within 2 or 3 hearings of the matter, sometimes the matters are dismissed. Sometimes as soon as the matter is set for trial, certain witnesses don't come because of whatever reasons. The witnesses come, they are cross-examined, they are found to be discredited by defense counsel, and the defendants before the courts are acquitted. So I don't think the position is that we are going to attach guilt automatically to someone who has been charged. That is not the position for anyone before the courts of law. And that is why, in terms of our position with respect to bail amendment and all of those things that would traverse the parliament, our position is that essentially that a person has a right to go before the court, have their matter properly ventilated, and let the chips fall where they may, subsequent to due process, which is what the Constitution provides for us to do. We've never waned or changed our position from that.
What about those who suggest that, well, while it's a legally binding position, for a person to be charged, a particular benchmark has to be met. Person still innocent until proven guilty. Yeah. So the office of the DPP, and that is maybe serious enough to consider the person withdrawing until their name is cleared.
As I said before, I think with an elected official, it's a bit more complicated than that, because then what you would essentially have is a by-election taking place and whatnot. I mean, I declare my position. I am a personal friend of Dr. Lee, apart from us being a party. I would have tendered some advice on the matter, so I can't get into it definitely at this stage. I have a particular position based upon the advice that I would have given in the matter.
You're involved, so you can't comment.
Well, not involved in terms of representation, right?
Yeah, but you're involved at some level.
And I am hopeful, and I would go more than saying hopeful. I'm very confident that at the end of the day, when this matter is ventilated, that he would in fact be acquitted. But we will wait and let them have their day in court. That's my position.
Sean Silvers, thanks for being with us. Appreciate your time. Been a while.
So much long time. The opportunity for having me on. Thank you, Mr. Ragoobarsingh. Thank you, Dr. Richards, and Mr. Khan as well too.
Paul still works very well.
I have to say,
Paul still works very, very well.
You've worked. I mean, I don't think people understand how difficult a thesis is.
They have no idea.
Correct, right?
This is the result of the thesis, a great beer.
So when you it, you deserve to be called it.
It doesn't matter to me. It's the information and the knowledge that's important to me. The title is still Paul. But thank you so much.
No problem then, Doctor.
All right. Thank you so much.
All the best to you. Paul Richards being gracious and polite and humble.
It's raining, so
it's like an auspicious moment.
Well, we stay waiting for your auspicious moment, the Ragoobarsingh. Have a great day, show. Thanks a lot.
Recording stopped.
All right, gentlemen, we got to pause. We got to get into our news brief, and it's all courtesy Champlain Auto Services.